Thank you, Mr. Chairman. I'm delighted to be here and have an opportunity to interact again with Eva Joly and Ms. Alfano. In 1997, when I was traveling the world interviewing people in preparation for a book that I wrote on illicit financial flows, I interviewed a Swiss banker in Switzerland, and I gave to this gentleman anonymity so that he would speak frankly with me, and he said, as long as tax evading money is not on the same level as drug money, then we cannot curtail money laundering. He put his finger right on the key issue. As long as we hold open the shadow financial system for the purpose of handling tax evading and tax avoiding money, then we cannot expect that system to curtail the movement of criminal and corrupt money. In Global Financial Integrity, we study the global movement of illicit financial flows, and particularly as they affect developing countries. In our analysis for 2011, is $783 billion moving out of developing countries into Western economies unrecorded, illegally and unrecorded. $783 billion is our analysis. So that's down slightly from our analyses for the two preceding years. But think of how that has accumulated over a period of time into trillions and trillions of dollars that have moved out of the developing world into Western economies. We did a study of transnational crime in the developing world and produced a figure of $650 billion in 12 categories of criminal activities. There were another 12 categories that we did not analyze, but we included in that, in our analysis, drugs and trafficking and counterfeiting and contraband and so forth. So we're talking about hundreds of billions of dollars affecting the developing world. How does this money flow? It flows through a shadow financial system which we created. It's important to understand that it was not the people in the countries out of which the money comes who created this system. It was created by those of us who live in the countries into which the money arrives. This system now comprises a number of elements. Tax havens. When I started in the business world in the early 1960s, there were 4 or 5 tax havens around the world. There are now more than 60 spread across the globe. Almost all of these tax havens function as secrecy jurisdictions. That means they have the infrastructure of lawyers and bankers and accountants who can create entities that hide behind nominees and trustees such that no one knows who are the real owners of these entities. These disguised entities, mostly shell corporations, now number in the millions and millions around the world. Anonymous trust accounts are part of this structure. Fake foundations are part of this structure. Falsified pricing is used in all sorts of trade and capital transactions, particularly in the manipulation of prices in imports and exports. This accounts for the fact that about 60 to 70% of the illegal money flowing across borders stems from commercial activities. Crime, which is part of the subject that we're talking about today, criminal activities account for about 30 or 35% of the cross-border movement of money. The corrupt component, that is money stolen through bribery and theft by government officials, amounts to only about 5% of the global total. Another element of the system that shifts money around the world are various money laundering techniques that are used mostly for specialized purposes. And then finally, there are laws left in the holds of Western corporations that facilitate the movement of money through this shadow financial system and ultimately into our Western economies, holes left in our own laws. We have been deeply involved in the fight against drugs and crime and money laundering for more than 25 years now. We are not succeeding. We are failing. We have no indication in our work that the growth of money laundering has turned down. Every bit of analysis that we are able to do indicates that it is continuing to rise. Drugs have not been reduced either in volume or particularly affected in price. Cross-border crime of other forms has exploded over the last 20 or 25 years. The key fallacy in global anti-money laundering efforts is the idea that we can hold on to our use of the shadow financial system to move tax evading and tax avoiding money, while at the same time making others give up their use of the same system for the purpose of moving criminal and corrupt money. This is not possible. This is a subject matter where we can succeed only when we address all parts of the problem. The center of gravity has shifted in recent years to you here in Europe. In earlier years, the United States took the lead in addressing these kinds of issues. We passed the Foreign Corrupt Practices Act in 1977, which made it illegal to bribe foreign government officials. We initiated a number of anti-money laundering procedures in the 1980s. We encouraged the G7 to create a global anti-money laundering body, which became the Financial Action Task Force. But today, the European Union is in the forefront on addressing these kinds of issues. And there are a great many positive steps, including directives from the EU Commission, from the European Commission, and other activities that you are undertaking. I would like to address two areas where I believe additional progress needs to be made. Two areas of weakness where I think a great deal more needs to be done. And these two areas are beneficial ownership and tax fraud. Beneficial ownership, of course, means who are the natural persons that own accounts. Let me begin my remarks on beneficial ownership by pointing out that there is no argument in favor of not knowing with whom you are doing business. There is no argument in favor of not knowing who are the natural persons that own the accounts with which we're dealing. And yet there are millions and millions of accounts in your banks and our banks and other financial institutions where we do not know who are the natural persons that own those accounts. In the materials that I have reviewed that are before you at the present time, I do not see sufficient disincentive for the creation of shell corporations and anonymous accounts and for the facilitation of the financial activities of these shell corporations. I'd like to suggest two ways in which this aspect of legislation can be strengthened. First of all, concerning shell corporations, outlaw them. What a radical thought. Well, is it so radical? After 9/11 in the United States, the U.S. Congress passed the USA Patriot Act. The Patriot Act has in it a strengthened anti-money laundering section, Title III. Within Title III, shell banks were addressed. Shell banks were the same thing as shell corporations. They were banks that could operate behind nominees and trustees such that no one knew who owned the bank. The USA Patriot Act says it is illegal for any U.S. financial institution to receive money from a foreign shell bank. It goes on to say it is illegal for any other financial institution in the world to send money to the United States that it has received from a foreign shell bank. It goes on to make it clear that this even refers to wire transfers that might touch a correspondent banking account in New York before going off somewhere else. What happened? Immediately when the Patriot Act was passed, shell banks were closed across the world. They went from thousands to a handful, just like that, as a matter of political will on the part of the United States addressing that aspect of the global shadow financial system. There are still a handful of shell banks operating in Europe and in Asia, being very careful to see to it that their transactions never touch a correspondent banking account in the United States. But almost completely, shell banks were taken off the table just like that. The same thing can be done with shell corporations. It's a matter of political will. Now, if that is too much to contemplate, there is another step toward beneficial ownership that can address this problem, and that is public registries of who are the owners of entities. At the place of incorporation, a public registry of who are the natural persons owning those accounts. Corporations are established by the state. The state has a right to know who are the people that are owning this account, and the public, which the state represents, has a right to know who are the people owning these entities. Public registries would be another way of handling the issue of determination of beneficial ownership. Next point that I would like to talk about is tax fraud. The biggest part of tax fraud is abusive transfer pricing in multinational corporations and the mispricing of trade between unrelated parties, done for the purpose of varying import and export prices on trade transactions to manipulate VAT taxes, customs duties, income taxes, or excise taxes, or other sources of revenues for governments. There was a very interesting case in the United States that was decided by the Supreme Court in 2005. The case was called U.S. versus Pasquantino. Pasquantino and his colleagues had conspired to smuggle liquor from the United States into Canada. The Supreme Court ruled that this constituted a scheme to defraud. What was interesting about the Pasquantino case is that it did not hinge on who was defrauded, in this case the Canadian government, or of what they were defrauded, in this case customs duties. It simply said, you have sat yourselves down in the United States and you have indulged in a scheme to defraud. That was a criminal offense under that, under the decision of the Supreme Court. Think how many decisions of exactly that nature are made in corporations all over the world every day, where decisions are made to manipulate the VAT taxes, customs duties, income taxes, excise taxes of either the country of export or the country of import in trade transactions. When corporation executives and managers are indulging in these kinds of transactions, are they committing a felony offense? I think this needs to be clarified in the proposals that are before you now. Tax fraud needs to be clarified that it does encompass abusive transfer pricing and the mispricing of trade between unrelated parties, where the substance of the transaction of this activity is intended to manipulate VAT taxes, customs duties, income taxes, or excise taxes. I would very much encourage the European Union to consider strengthening these two aspects of what is before you now: beneficial ownership and tax fraud. Thank you.